Good morning, everyone. I think we're getting ready to start. I'm Patty Griffin, General Counsel here at ANSI, and I am thrilled to welcome you to our annual Legal Issues Forum. I'm just so glad everybody's here. It's such a great group. We've got a full day of really great discussion on topics that matter to anyone working in standards and conformity assessment. So this year, we're tackling two big issues that have huge implications for our community. First up, we'll dive into the legal side of artificial intelligence and how it affects content, including standards. Yesterday, we talked about AI in the manufacturing context, but today we're focused on the legal nitty-gritty, things like copyright, fair use, and what responsible AI adoption looks like. Then our second panel is going to explore something really timely, how U.S. deregulation is changing the game for standards and conformity assessment. As federal regulations get rolled back, does that mean there's a bigger need for what we do? Is there a gap we can help fill? Our panelists are going to dig into these questions. We've got really an amazing lineup to guide us through all of this. We have legal experts, industry leaders, standards professionals, and all of them really know their stuff. And I see Marriott has made sure that there will be no comfortable chairs for the lawyers on this panel, so maybe they'll be at the top of their game. Speaking of lawyers, just a quick note about CLE credits for the lawyers in the room. Make sure you sign the CLE sheet at the registration table when you arrive, and if you want to go do that right now, that's fine. Make sure, and this is really important, make sure you go back at the end of this session and sign out of the program again, and that's how we're able to track and make sure you get all your credits. Another housekeeping matter, I understand that each of you should be scanning your code on the ticket that you're wearing around your neck. That helps us understand who's registered and who's not. So let me get started. It's such a great pleasure to introduce our first keynote speaker, Miranda Means. Miranda is a partner at Kirkland & Ellis's Boston office, where she focuses on intellectual property, counseling, covering copyright, trade secret, trademark, rights of publicity, art, internet, and advertising law. Miranda has been recognized for her work by The American Lawyer, which named her Litigator of the Week in connection with her work on the first AI copyright fair use case in the United States. She represented in that case Thomson Reuters in Thomson Reuters versus Ross Intelligence. In that role, she helped secure the nation's first summary judgment holding that training AI models on copyright materials does not constitute fair use. So please join me in welcoming Miranda Means.
Good morning, everyone. So in this keynote, I want to set the table for the discussion that's going to follow in this panel. Obviously, that's quite a big table. There's lots of different legal issues at play in the AI space. So I'm going to hit things at a higher level, and then hopefully the panel will cover the details, and if you have questions after, we can address those. As I walk through these legal problems, I'm mindful that you may occupy multiple perspectives on this. As standard setters, you're rights holders, and you may have intellectual property concerns about the use of your standards and the unauthorized exploitation of them. But you may also use AI tools in your everyday work and want to know how to ethically continue to do that. And of course, you may also be considering the types of standards to develop around the creation and use of AI and how to ethically do that. So I hope this introduction and the following panel will be instructive on all three of those perspectives. So I want to present two big problems in this space in connection with intellectual property rights. The first big problem in this space is who owns the content that's generated by AI? Now, there's four possible options, right? The first option is that the content generated by AI belongs to the person who prompted the AI. I teach a class at Harvard Law School, and this was the most compelling point for them. The students felt that anything that's generated by AI should belong to the prompter, that it's creative to put in a bunch of different prompts, that it requires work and effort. And so if you do that, you should own the resulting content. But there's other options. The second option is that the content that's generated by the AI should belong to the company that programmed it, that trained it, that developed it. The third option, which some people have presented, is that the content generated by the AI belongs to the AI itself, that the AI should own that work, whatever that could mean. And then the fourth option is that the content that's generated by AI prompting belongs to no one, that it's out in the world, in the public domain, and can be used by anyone. So these are kind of the four options that we've been presented with in terms of ownership of what's being created by AI systems. And copyright law, which governs the rights of authors in expressive works, provides some answers here. And I think one of our panelists is going to talk in more detail about these answers. But the basic answer is, at the very least, copyright law seems to eliminate option 3, ownership by the AI system. Copyright law says that to own a work, you need to be a human author, that copyrights don't extend to non-human creators. And so that seems to potentially eliminate option 3. And we've also received some guidance from the Copyright Office. In January 2025, the Copyright Office said that for a copyright registration in a work, there needs to be sufficient human control over the expressive elements of the work. So while the practical application of that is still ongoing, and we have yet to see exactly how that's going to go, it seems like if a human has created an element of the resulting work, so for example, if a human draws on top of a work created by artificial intelligence, or if a human selects and arranges pieces of work that have been created by artificial intelligence, perhaps that human author can get a copyright in that human creation. So for example, in a comic book, if the comic book panels were generated purely by AI prompting, but the selection and arrangement of the comic book, the wording, was created by a human author, then perhaps the human author could protect their selection and arrangement and the wording, but not the underlying AI images. Now this is, and we'll have a panelist talk more in detail about this. This is Copyright Office guidance. We have some court cases about this, but obviously we have yet to see how this could play out in more complicated contexts involving human control and participation in AI-generated works. So it's not so simple a question, and I'm sure we'll see more in the future on that. But that question of ownership is kind of the first big problem in this space that we've all been grappling with. The second problem, and maybe the thornier one, the one that's led to much more litigation, is the infringement question. So there's two ways that infringement of copyrights comes up in the AI context. One is with respect to what's going into the AI system, and the other context is what's the AI system is spitting out. So what's being generated by the AI. These are also called the input and the output cases. So if you hear our panelists referring to those, that's what it means. Input is what you're putting into the AI. Output is what the AI is spitting out. So let's start with the first of these, the input case. So creating an AI system can involve training an algorithm on a large quantity of content. And that content can range from books, news articles, music, and more. The content may be copied at multiple different stages of the training process, and some AI companies are not only copying the content, but they're also storing and librarying it as well. Some AI companies have licensed that content, the training content, from copyright holders for this purpose. They've entered deals where they either share in the profits of their AI systems or maybe license that content for this use and are using it that way. Other AI companies are using the content without paying the copyright holders. Some of this content is coming from scraping the public internet, So for website holders, especially if content isn't paywalled, then it's possible that an AI developer can scrape the website for content for training. Some of that content is coming from pirated data sets, like pirated books data sets, which we'll talk about a little bit more momentarily. And some of that content is coming from other sources, such as going out and purchasing content in books and then scanning those books digitally and then training on those digital copies. So we have a bunch of different ways that AI companies are obtaining content and a bunch of different possible issues that come out of that. So let's start by thinking about this issue from the perspective of the copyright holder, and then we'll talk about it from the perspective of the AI companies. So for the copyright holder, there are a few different concerns with this training process. The first is some copyright holders are specifically concerned about scraping. There have been research to suggest that the use of bots can be disruptive to websites. There's a lot more bots now. AI companies are going out and scraping websites. That can be disruptive. So that's one concern. There are ways to deal with that. As a website, you can engage with what's called the robots.txt protocol, but it can be tricky to enforce that method, and some AI companies may disregard it. Some websites also have terms and conditions that limit bots' ability to scrape content, but those aren't always abided by. And then, of course, if they're not, if you're a copyright holder, you're in court trying to enforce them. Second, and the bigger concern on the copyright holder side, is that the AI companies are copying large swaths of content, including potentially pirated content, without permission or payment to the copyright holder. And so copyright owners assert that those takings are copyright infringement, and that there's a problem here because the resulting works, if you're training on a book and your algorithm produces books and written content, the problem with that for copyright holders is that that could swamp the market for their works, it could compete and replace their works, and in general, artists are concerned that they're being replaced by AI. And not only being replaced by AI, but being replaced by AI that's trained on their own content, so their own books and artworks and all other sorts of copyrighted content. So there's an existential threat from the copyright holder view. On the AI company side, the perspective is obviously different, and there's also a sense of an existential threat. AI companies have argued that they need large quantities of content to train their algorithms. Some have argued they can't train without scraping, and they can't train without human content. There has been research to show that training an AI on AI-generated content isn't enough. Right? So there's an argument that this is necessary, and that AI systems are transformative because they allow users to create something new and different from what's being ingested. And so some AI companies argue that enforcement of copyrights in this context would be stifling to innovation. So there's kind of a third, I'm presenting this as copyright holders versus AI companies, and that's often how we've seen the litigations come out, but there's a third group, a third perspective, which is AI companies and industry organizations that contend that there are ethical ways to do this training, that there are ways to do it where they partner with copyright holders or engage in business solutions that don't involve simply copying without permission. So some of the business solutions we've seen, I sort of mentioned, are various deals, revenue sharing deals with copyright holders. There have been proposals to do an opt-in system where copyright holders opt in to having their copyrighted content used in the training process. And there's been discussions of an opt-out system, similar to robots.txt, which robots.txt, for those who aren't familiar, if you have a website, you can control which bots, or you can at least set up a protocol to say which bots are allowed to scrape your website and which aren't. So there's been discussion of that. Maybe copyright holders can opt in or opt out of this training. So in terms of business solutions, I can get a little more into detail on it momentarily, but let's talk about answers from the court, because there have been over 30 lawsuits filed about this issue of training on copyrighted content, and many of them are more recent, so they're still working their way through the system, but some of them have been decided. As Patty graciously talked about the case Thomson Reuters v. Ross, which was the first case to decide these issues in the United States. That case was decided, and then we had 2 more cases decided this year on this issue. So I'll start with Thomson Reuters v. Ross. So that case involved a AI company called Ross Intelligence that obtained content from Westlaw, including West head notes and West key numbers, and used that content to train its AI algorithm to power a competing legal research platform that it marketed as a replacement for Westlaw. So this case has been pending for a few years. It worked its way through summary judgment, and the district court granted summary judgment for Thomson Reuters, finding that Ross had not only infringed, but its fair use defense did not apply. So the court rejected that defense for a few different reasons. First, the court held that Ross's use was commercial. It was putting out a for-profit legal research platform, and that this weighed against fair use. So training an AI for nonprofit research purposes might be different under this case, but in this case, the court found that this was a commercial purpose, and that weighed against fair use. The court also found that Ross's use was for the same purpose as Westlaw, to create a legal research tool to find relevant law, and that competed directly with the original content. And so that weighed against the fair use defense applying. You can imagine scenarios where that might not be true of every single AI system. For example, if you have an AI algorithm that helps you identify cancerous cells on the body, and that's trained on movies and photographs, then perhaps you might have a different argument. If it's commercial, maybe you would still argue that fair use doesn't apply, but you can see how this analysis is very, very fact dependent, and different courts may come out differently depending on the purpose of the AI. And in this case, Thomson Reuters, the court also focused on the harm to the market for the original copyrighted content. So it found that by competing with Westlaw in the market and usurping potential licensing opportunities for Westlaw content as training data, that weighed against fair use. And so copyright enforcement was appropriate, and the court granted summary judgment. These issues are up on appeal before the Third Circuit, and so that case is still working its way through the system. 2 more cases came out this year on the same input issue. The first is Bartz v. Anthropic, which some of you may have seen in the news because it made a big splash because of the settlement. That case involved authors of copyrighted books who brought a putative class action against Anthropic, which creates Claude, the AI system. So Anthropic had lawfully purchased some books to train its AI, but it had also used a pirated data set of books. The court found that using the books to train the AI algorithm was a fair use, so this court came out differently than Thomson Reuters. It found that it was a fair use because, like any reader aspiring to be a writer, Anthropic's LLM trained upon works not to race ahead and replicate or supplant them, but to emulate a blend of their best writing. So it was doing something different, according to this court, than the original purpose of the works. The court distinguished the Thomson Reuters case, noting that there, Ross had copied to create a direct substitute for the Westlaw content, and so that was a different type of case, according to this court. And the court did find that storing the pirated books for Claude's digital library, so there was 2 issues. One was using the books to train, and the other was storing and librarying pirated books. The court found that that second issue, storing, and librarying pirated books was not a fair use. And so in September, after that summary judgment holding came out, the case was continuing. The court certified the class action, and the parties announced a $1.5 billion settlement in September, which is the largest copyright settlement in US history. So that's maybe why you saw it in the news. I think it was front page of New York Times, but these are obviously big cases with big liability potential, as you can imagine. So the third lawsuit that that has come down this year is Kadri v. Meta. Similar issues to Anthropic. This involved a group of famous authors asserting that Meta trained using their books, trained their Llama large language model. The court found that fair use did apply here because the use was different from the original purpose of the books. But the court did give credence to the theory that AI-generated works might hurt the market for the original work by flooding it with a bunch of AI-generated versions. The court found that there wasn't sufficient evidence of that harm to weigh against fair use. And so the court ultimately found fair use apply. So as you can kind of hopefully tell through these different cases, courts are thinking about a few things. They're thinking about the purpose. What's the purpose of the AI algorithm? And what's the purpose of the original content? And they're thinking about the markets for that content and how much the copyrighted work, the market for the copyrighted work, and the potential market for the copyrighted work is harmed by the generative AI. So that's the input case. I'm going to briefly touch on the output case. So the output case is a situation where the AI algorithm spits out an image, a piece of music, a piece of writing, or other content that's substantially similar to a copyright holder's work. So in that case, the output is generated by the prompting of the user. So that creates a bit of a challenge. In this situation where a copy of a work is being created, who is responsible for generating the result? We talked about authorship and prompting and whether that makes you an author. Here's kind of the flip side. Is the prompter the one who's infringing, or is the AI company liable for that output? Now, in the copyright world, a finding of direct liability requires some sort of volitional conduct that causes the infringement. So we'll see how this plays out, but some have argued, well, there's no volitional conduct on the part of the AI company. In that scenario, it's really all down to the prompter. And other people have argued that, well, if the prompt's kind of vague, but the AI generates something really specific that's copyright infringement, maybe that isn't the prompter's volitional conduct. Maybe it is attributable to the AI company. We'll see how that plays out. But in copyright, you can also be liable for somebody else's copying. It's called secondary liability. And there are a few pending litigations asserting that AI companies are secondarily liable for the copying of the users who are prompting their algorithms to spit out infringing works. So we don't have super clear case law on this yet. We don't have clear case law on anything, as you've seen. But there are multiple cases on that issue working their way through the system to keep an eye on. So there are 2 lawsuits currently pending against Midjourney, which is a generative AI company, by Warner Brothers and Disney, alleging that Midjourney infringes on their IP by producing outputs that resemble the copyrighted work. These cases allege a theory of secondary liability, that Midjourney is responsible for the infringement of its users. And we'll see how these cases turn out and whether those theories could apply. And I will mention there probably will also be some fair use arguments in there too, and those arguments may look different in that context than the training data context. So very briefly, I'll hit on a few other rights that are implicated, because not all copyright that's involved here. There are also issues with state laws. Lots of states have passed legislation about different issues with AI, a lot focused on deep fakes, election fakes, things like that. Copyright is a federal issue, so states can't issue their own legislation on that, but they can, they have put forward legislation, and many states have passed legislation about things like the use of individuals' images in AI and election information. There's another area that sometimes comes up in this space, trademarks. What if an AI system is generating content that features a trademark or a logo? What if it's doing that a lot? Could that suggest an affiliation with a specific company? Or what if the AI system is generating content that it attributes to a particular company that that company never said or doesn't want to be affiliated with? Ultimately, this is going to be a highly fact-dependent analysis, and we'll see how it is working its way through the courts as well, and we'll see how courts come out on it. But just another place that IP comes in. And then right of publicity is another issue that we see. So if the AI model is generating images of real people that might implicate their right of publicity, could they sue as a result? And then finally, along those same lines, is defamation. You know, what if the AI gives you, we all know some AI systems hallucinate and you can't always trust what it's saying. We've seen these ethics cases come up where lawyers use AI to generate cases that don't exist and things like that. So what if the AI model says something false about me? Do I have a defamation claim against the AI company? What if it was prompted by the user? Did they really say it? These are all questions that we're going to see come up throughout, I think, the next few years as all of these things are litigated and we get more guidance on them. So our panel is going to talk more about regulation and get more into the nitty-gritty of these issues. So I don't want to go into too much detail yet. I hope you at least have a high-level understanding of all of the different types of issues at play here. Obviously, the landscape is complex, and it is hard to tell exactly where things are going. But the bottom line, I think, is while many courts haven't weighed in yet, on the side, AI companies and other groups are trying to work out other solutions, standards, business solutions, as the courts work things out. We don't have, pending federal legislation that solves all of these problems, and we likely won't on copyright. The Copyright Act dates back to 1976. We haven't had an update since the 90s with the Digital Millennium Copyright Act, and it's unlikely we're going to get a super clear federal statute on this in the next couple of years. So in the background, people are trying to work out other types of solutions as things are still working through the courts. So for example, OpenAI's Sora 2 launched with the introduction of a feature that required copyright holders to affirmatively opt out of generative AI content. Sora redacted that policy recently and announced instead it had moved to an opt-in model requiring copyright holders to grant permission before copyrighted characters can appear in Sora-generated videos. So it's just an example of one possible solution, an opt-in solution where copyright holders who don't mind having, AI companies train on their works can opt in, and others can not choose to do that. So that's just one possible solution. There's lots of different issues at play, as you can see, so we're excited to see what the future holds, and I'm going to turn it over to our panel to give you some of the details. Thank you so much.
Thank you so much, Miranda, for providing us with such enlightening insights and getting this discussion started. Now it's my pleasure to introduce the moderator for our first panel, Andy Updegrove. Andy, as many of you know, is a founding partner at Gesmer Updegrove LLP, where he's advised more than 200 standard-setting and open-source organizations across diverse industries for more than 30 years. He also sits on the ANSI Board of Directors and the board of ANSI's affiliate, WorkCred. Andy helped shape every U.S. standard strategy revision since 2004 and earned ANSI's President's Award for Journalism in 2005, and just last evening, ANSI won the prestigious Chairman's Award. Andy's a graduate of Yale University and the Cornell University Law School. Please join me in welcoming Andy Updegrove.
Thanks very much, Patty. So welcome to the wonderful world of AI. It's a world that we've been promised for over 60 years through times of AI winter, where things were more negatively framed, to hype phases where we thought that AI and even advanced AI or general AI was just around the corner, or as people usually figured, it was 20 years away and always would be. But today it's here. You know, it's actually out there, it's everywhere. We have it accessed from our laptop, from our phone, from commercial products to free tools. So we're finding out that it's interesting times now that it's finally here. So we're talking today about those interesting times from a legal perspective. It's always difficult to come second, so I'm going to mostly just reframe what you just heard. But you know, to start with, as Miranda just pointed out, the U.S. Copyright Office's initial guidance is that no, copyrighted works have to be created by humans. And the USPTO has come to the same decision that in order to be an inventor, you have to be a human being. But then we are one country out of over 200, and where the rest of the world will come out, you know, obviously is something else again. I would also note that just 2 weeks ago, a new funding round was announced by a company, a startup, that is created solely to do AI inventions. And that round was $300 million. So you can imagine, with all the other money that's going into AI startups, how long that conclusion that you can't own the intellectual property that is created by the companies that you put billions and billions of dollars into. I just sort of posed the question, no matter what the USPTO thinks today or the Copyright Office thinks today, will they hold up against what one would imagine would be armies of lobbyists that are going to be urging them to come to a different conclusion? So, you know, that's a wait and see. Meanwhile, LLMs have become so voracious that they've hoovered up all the data in the world, and that isn't enough. So they're also now creating their own training data. They're already hallucinating, but you know, what could go wrong? Meanwhile, it will probably be years before U.S. courts and or Congress, if it ever comes back, will resolve definitively whether this is fair use. And again, decisions abroad may vary. For now, different courts are yielding different results, and the $1.5 billion Anthropic Accord puts into play a near-term thread where people who are already engaged in litigation or threatened with litigation or setting up AI training programs will take that into account as well. I mean, my own books have been scraped. It's kind of interesting now. I can type in, come up with a new book in the style of Andy Updegrove, and it will do so. Thankfully not very well, but you know, it will do exactly that work. Someone could go online and say, please help me create a pirated work of this particular author. So that's today, that's here. Other issues bring up different challenges: privacy, liability, bias, and so on, all the things that you've been reading in the news. So again, how long will it take to reach consensus at home and abroad on who will bear responsibility when things go wrong, and what will the likely result be? If you look at the EU tends to be ahead of the US these days in regulatory matters. They're already going on their own way with laws, regulations, and yes, standards, as we're all on the standard side painfully aware. So will US interests be fairly represented or at all across the water and elsewhere? If not, what's the potential for disruption or other adverse effects for US stakeholders? We'll just have to wait and see. If you look at China, for example, if you look at Europe, for example, they've now come up with a cybersecurity liability law, which will go into effect in 2027. It's already been enacted. It's going through the process of filtering out to the states, something that's way ahead of what we have in the US. So again, one would assume that we already have AI action in the EU at the government level. We'll see where that goes and where the US goes in turn. Currently, under the current administration, one would assume that there'll be differences in directions. How will that resolve? How will that play out? Particularly where you're talking about on the internet, on the web, which don't recognize borders. In the same vein, crucial standards consortia based in the US are again considering moving offshore. A lot of our clients actually did that 5 years ago when the BIS export controls confusion happened. Well, now they're happening again. We actually have clients that are moving offshore. And it's not because it's going to make any difference. Their members will still be subject to exactly the same export laws. So it's more of a political statement in the first instance. But second of all, because they don't know what to expect next. So these are real impacts on American interests. Similarly, another client of ours, there was a editorial in the Washington Times just 2 days ago saying that the government should prohibit American companies from participating in this consortia because Chinese companies were already there. So when you're talking about key areas like AI, like silicon designs, those areas that have been identified as key technologies both in the US and China, we don't know where that's going to go. At the same time, of course, AI offers a wealth of new opportunities, or at least so legions of vendors of new tools are assuring us. But are these tools ready to be useful for standards developers and conformity assessors? Surveys tell us that many early adopters in other sectors have found that their investments in new AI tools are not paying off yet, 85% in one recent poll. Those of us with gray hair will recall what the economists called the computer paradox, because it took decades before the impact of computers finally made any meaningful impact on productivity. All of which means that there are challenges as well as opportunities, especially for SDOs and consortia, which are at the very small end of the definition of an SME. When is the right time for them to plunge into AI, and how? Today, we're fortunate to have experts able to cover all of these issues, building on the excellent keynote address you've just heard. I'll briefly go over their bios, which you can also find in the materials on the tables. Our first speaker will be Laura Caroli, who's a senior fellow of the Wani AI Center at the Center for Strategic and International Studies. I'm going to shorten these a bit in the interest of time, but you have the full versions on your table. George Davis is counsel at McGuire Woods. As part of the firm's commercial litigation department, George focuses his practice on intellectual property litigation, specifically patent and trade secrets litigation. Brian Scarpelli is senior global counsel at ACT, the App Association, a not-for-profit trade association representing the small business technology developer community, where he works on a wide array of legal and policy issues impacting mobile app development companies. And finally, Fabio Thieres is a recognized expert in AI governance, process automation, and standards-based validation. He has over 20 years of experience designing and developing digital product platforms, managing AI product performance evaluation studies, and much more. As far as the program, George will lead off and he'll provide comments from the regulatory and government perspective. He'll be followed by Laura, who will present an international perspective. Fabio will help us understand. Gee, did I not read? I'm sorry, yes I did. Fabio will help us understand what IA will mean for conformity assessment, and Brian will conclude the formal presentations from an industry perspective. We'll do some questions along the way, but we've reserved a good amount of time at the end of the presentations to take all of your questions. So with that, George, please take it away.
Thank you.
Thank you.
Thanks, Andy. Good morning. My name is George Davis. As Andy said, I'm counsel with the law firm of McGuire Woods, practicing primarily in intellectual property litigation. This morning, I will not be talking about litigation. I thought Miranda did an excellent job of kind of surveying the landscape there. What I'd like to talk about for the time I have is two things. The first is how the Copyright Office itself has been responding to AI-generated works that are submitted for registration. And then the second, briefly, is to touch on some recent executive orders from the Trump administration that relate to AI. So starting with the Copyright Office, as Miranda said, about 2.5 years ago in March of 2023, there was some initial guidance published by the Copyright Office relating to AI. It was part of its comprehensive AI initiative. And they restated a couple things. One is that the requirement that there must be a human author. So if you use AI, you still, to get a copyright, there has to be a human author involved. The second is to require any applicant who uses AI to help generate their work had to disclose that to the Copyright Office as part of their registration. And in addition to that, they had to provide a brief explanation of what the human author's contributions were to the work. And then the last thing that the policy started doing is to clarify that while you certainly could use AI as a tool to generate a work, the copyright itself, to the extent you could receive one, would only protect the human-authored aspects of that work. So following this, in 2023, there were a number of listening sessions that the office held. There was a formal notice that was published in August, and then I think about more than 10,000 public comments were received from the public on that initial notice. So during that time, and Miranda touched on this a little bit, but the Copyright Office itself was really starting to deal in a significant way with AI-generated works. And I think it would be helpful to kind of illustrate an example that's published on the Copyright Office's website. It's a decision by the Copyright Review Board from December of 2023 for a work called Suryast. So I'm going to go to the next slide. So you can see on this slide on the far right, that is the image that was submitted as part of a copyright registration application in 2021. It was called Suryast, and as part of that application, the applicant disclosed that he had used an AI painting app called RagHav to generate this work. And so in 2022, the Copyright Office refused to register that work, and they said it lacked human authorship necessary to support a copyright claim. So the applicant asked for reconsideration. That reconsideration was denied. And then again, the applicant in 2023 went to the Copyright Review Board. And the Copyright Review Board is sort of at the administrative level, it's sort of the court of last appeal for anyone who's been denied a copyright registration. So in December of 2023, the board issued a decision on the Suryast application. And if we go to the next slide, I think it would be helpful just to understand exactly how the applicant used AI to generate the work that he was seeking to register. So on the far left, what he started with, he had 3 inputs that he used for this, to generate this work. And the first was an actual image that he took. It was a photograph, and that's on the left. It's a photograph of a sunset. Obviously, that itself, if he had sought to register that, would have certainly been copyrightable. And then the second thing he input to the AI system was Vincent van Gogh's Starry Night. And the third thing he input was it's called a style transfer value. And so what the AI application was designed to do was to essentially take a base image, which is what's shown on the left, and then a style image, and then with the style transfer value, which is just a numerical value, was essentially telling the AI system, how much of the style image should you interpolate onto the base image. So you're generating a new image based on the base image, but it's supposed to be in the style of the style image. And so again, there were 3 inputs: the base image, which was a photograph, the style image, which was Vincent van Gogh's Starry Night, and then a numerical value to sort of tell the AI system, this is sort of how much of the style image I want you to use to interpolate the base image. And so what the applicant got out of the AI system was the Suryast image on the far right. And that's what he submitted to the Copyright Office. He didn't make any changes to it. He didn't modify it. He just submitted it for registration. And so in December of 2023, the board had to consider, in the Suryast image, was there sufficient human authorship necessary to sustain a claim of copyright? And the board's decision was no. There was not. And the kind of key language from the board's decision was they found that the expressive elements of pictorial authorship were not provided by Mr. Sani, who is the applicant. He only provided 3 inputs, as I said, but he was not responsible for determining how to interpolate the base and style images in accordance with the style transfer value. So the fact that the work that he sought to register had a sunset, it had clouds, it had a building, in the board's mind, those were not the results of Mr. Sani, those were the results of the AI tool itself. So Mr. Sani did not control where those elements would be placed, where they would appear in the output, and what colors would be applied to them. That was all determined by the AI application, and so for that reason, the board said, no, we're not going to give you a copyright on this work. And so, as a result of that, the Copyright Office has continued to publish additional guidance. So in 2024, about a year and a half ago, and Miranda touched on this, they started issuing a series of reports. So the first one was in July of 2024, and that initial report addressed digital replicas. So a common example of this would be deepfakes. And the Copyright Office is really looking at, do we need new federal legislation to deal with these? And the Copyright Office's conclusion was, yes, we do. They didn't recommend any specific legislation, but there has, I think, been legislation that's at least been proposed in Congress, although I don't think it's really gone anywhere at this point. Then in January of 2025, they issued a second set of guidance, and that had to do with the same issues that were at play in the Surias decision, and that is, so what is copyrightable when you're using AI? And so a couple things that guidance provided was AI outputs are copyrightable if the human author determines sufficient expressive elements. So one of the conclusions was that if you just provide a prompt to an AI system in the form of text, and you're not going to be able to get a copyright on whatever the AI system generates in response to that prompt. So just providing a prompt is not going to be considered kind of sufficient expressive elements on the part of the human author. Now, the Copyright Office guidance said it's going to be a case-by-case analysis, which is a great vague term that, in a cynical view, kind of gives the office the ability to do whatever it wants, just sort of how it feels about the work. But I think there have been other decisions that kind of give you an idea of the types of works that are considered copyrightable. So Miranda touched on one. For example, if you were to generate a bunch of AI images and then put those into a collage yourself and sort of arrange them in a certain way, that could be considered copyrightable, according to this guidance. So moving past the Copyright Office, I'd like to spend the last few minutes talking briefly about a couple executive orders that the Trump administration has issued. These were all issued in July of this year, so just a few months ago, and they're part of the Trump administration's, what it's calling its AI action plan. The first, and I've just shown the titles of these on the slide, and they kind of give you an idea of what they're meant to do. But the first was called Accelerating Federal Permitting of Data Center Infrastructure. So in layman's terms, it just means let's build more data centers, and specifically data centers that are designed for supporting AI applications. So the goal was to fast track the construction of data centers in the United States, as well as the supporting infrastructure. So obviously, if you're building a data center, you need power lines, you need a power source, you need supporting network equipment, and the goal of this executive order was to sort of take advantage of different levers that are available to the federal government to sort of fast track environmental permitting, use federal land grants to provide to builders who want to build data centers, among other things. So that was the first executive order. The second is 14320. That really relates to the export of AI technology. And this sort of dovetails with what's been in the news a lot with the Trump administration's tariff policies. So the goal of this second executive order was to reduce U.S. dependence on foreign-made AI technologies and support domestic development of those technologies. So computer hardware, cloud services, again, data center storage, and to create what it calls AI export packages. Again, the details, as they are often in these types of executive orders, are fairly vague, but at a high level, it's let's have more AI development in the United States. and one thing to point to make about these executive orders is that it is a bit of a departure, or more than a bit of a departure from the prior administration, which took a more cautious approach to AI development. I think the Trump administration is trying to be a lot more aggressive in its development of AI. The last, and I present this without any commentary, is called Preventing Woke AI in the Federal Government. And the stated goal of this executive order was to reduce ideological bias in large language models, and specifically kind of providing guidance to federal agencies that want to use AI and go to AI vendors. And so those agencies will now have to follow guidance that will be provided shortly to sort of evaluate those AI vendors to ostensibly try to reduce the potential for ideological bias in the AI that those agencies are using. So I think I'm at the end of my time, but I think there might be a few questions that Andy wanted to ask, so thank you.
Well, George, thank you very much. I'm curious, when you look in your infallible crystal ball and your acquaintance with the Copyright Office, do you have any idea what we should expect in the future and when, how things will develop?
Yeah, I think, so one thing we're seeing is there have been other decisions to sort of give you an idea of the types of copyrighted works or types of registrations that would be considered copyrightable. So one example, I talked about the Suryass decision a second ago, which the board said, you don't get a copyright on that. But one example where the board or the Copyright Office did give a copyright registration was this image on the right, which is called Rose Enigma. And on the right, I believe that's, yeah, you're right. The image on the right was AI generated, and the base image or the input image was a hand-drawn picture on the left. So obviously the hand-drawn picture on the left itself would be considered copyrightable. And the office found that on the right, they thought there was sufficient human authorship that was detectable in the image on the right. And specifically, you can pretty clearly see the same kind of black outline of the face that's on the left. You can detect that fairly clearly on the right. And so the Copyright Office said, at least as to that part of the image on the right, we're going to give you a copyright for that. However, that copyright is limited, and the office actually included a disclaimer or an annotation on the registration that limited it to the unaltered kind of human authorship piece that is clearly perceptible in the image and separable from the non-human expression that is excluded from the claim. So as an example, the sort of outline on the right would be considered protectable or copyrightable, but the coloring, the shading, the kind of shape that's provided by the AI system of the face on the right, that wouldn't be considered copyrightable. So that's just an example of sort of where the Copyright Office is trying to draw the line between copyrightable expression in AI-generated images and images like the Suryass image, which the Copyright Office considered to be not enough human authorship.
And you mentioned that the Copyright Office had been doing a number of studies or reports. Do you know whether that process is ongoing?
It is. There's a third publication that came out. It was actually a pre-publication in May. And this one, and this is also something that Miranda touched on, but this study was meant to look at kind of policies and legislation around the use of copyrighted works to train large language models. And so what the Copyright Office said is it essentially took a lot of the arguments from the AI companies for around fair use and dispensed with a lot of them and said you're really taking this too far. But it also it said that current legislation or existing legislation is good enough and well developed enough to sort of respond to this issue. So TBD whether that will change as AI develops. But that's a pre-published version. That was in May of this year, and I think there will be a kind of a final publication before the end of the year.
And I had mentioned or speculated about the impact of lobbying. What do you would suppose is the possibility that there'll be an amendment to the copyright law by Congress, that would address either topics such as this or fair use?
I mean, anything's possible. As Miranda said, the Copyright Act was passed in 1976, and there hasn't really been a significant amendment to it in quite a while. And so I think, the Copyright Office's position at this point is that the law, as it exists now, is sufficient to to respond to the issues created by AI-generated images, but I wouldn't be surprised if, as that technology develops and if it's successful, that there might be a stronger push to see a significant amendment to the Copyright Act.
It's interesting when you look back at the Digital Millennium Copyright Act, there's enormous pressure by commercial interests, Google and others, and where they came out was, well, as long as you're not being too active in the activity on your sites, and as long as you honor takedown notices, you know, you can let people put up pretty much whatever they want, and that's now 25 years ago. So
Right.
content owners didn't come out very well on that one.
Yeah.
It'll be interesting to see what happens this time. So, Laura, take us in a new direction abroad.
Yes, thank you, Andrea. I'm very happy to be here with ANSI. Thank you for inviting me. I just want to start by saying that my previous role before joining CSIS in DC 1 year ago was to advise a member of the European Parliament, and in that role I was lucky enough to participate in co-leading negotiations on the EU AI Act on behalf of the European Parliament for 2 whole years, so I know all the ins and outs of it. And I'm here today because I've been exploring in my work all the similarities and differences in regulatory approaches between the US and the EU. You briefly mentioned this aspect earlier, and also the importance of standards in both processes, which I think is particularly relevant today. So indeed, I've been tracking in particular 2 types of state bills that are happening here in the US. One of them is, of course, you have the California SB 53, which was just signed by Governor Newsom, making it the first legal framework for frontier AI safety. You also have similar bills. One in New York, the RACE bill, was approved in June. You have similar ones in Michigan, Illinois, Massachusetts that are progressing. But these are targeting specifically frontier AI, so the most powerful AI models that have a computing power of 10 to the 26 flops, so that they are very, very powerful, and only a very small number of companies will have to comply with these rules. Let's start by saying this, because they are not sweeping bills, they will just target 2 companies, basically, or the likes. What I think is more interesting for the audience here today is actually the risk-based bills, such as the Colorado AI Act that was passed last year and was recently postponed, like in an extraordinary session this summer. The legislator agreed to postpone the application by 6 months, so instead of February 2026, it will enter into force in June 2026, because they're still figuring out exactly how to implement it. And there are other bills similar to that Colorado Act in the US. In particular, there was one in Virginia that was vetoed in March that was a lighter version of it. We have New Mexico, Connecticut, New York. They are all attempting to regulate with a risk-based approach to prevent what they call algorithmic discrimination. So basically they take areas similar to the UAI Act, such as education, employment, financial services, so lending, insurance, all sectors where the importance of an AI system producing an outcome that is accurate and fair is enormously important for the trust of the consumer and the smooth development of the market, but also upholding the rights of citizens and consumers, because it's, again, avoiding algorithmic discriminations and unfair decisions is extremely important to ensure this kind of trust. So in both these US algorithmic discrimination bills and the EU AI Act, standards are extremely important in two different ways, but still they are both. In both cases, they are very important. In the US, these algorithmic discrimination bills typically take the NIST risk management framework and ISO IEC 42001, so the AI management system standard, as a way to comply with the bills for both developers and deployers. I think this is very important to keep in mind when we go talk about the AI Act, the EU AI Act. So basically, both developers and deployers can implement these standards and more or less be safe from, this will be taken into account by the Attorney General in case there is a problem later on with the decisions with discrimination occurring in practice. Now, imagine, my point is, imagine a school, so education, right, is one of the high-risk areas. Imagine a school implementing a standard. Standards are typically very technical documents that are normally tackled by either legal offices and they are built by engineers in standardization organizations. So I personally, from the point of view of a European previous co-legislator, is a bit strange to see that the US, which is normally not heavily regulating, is asking deployers to implement a standard. Why am I saying this? Because in the EU AI Act, standards are completely super important. They are required, they are a means to comply for providers, so which are the developers here in the US, but not for the deployers. Deployers don't have to implement standards. They just need, in some cases, to assess the impact of an AI system on the rights of people, but they don't have to touch anything. They don't have to organize their internal processes in a certain way, such as the ISO IEC 4201 standard asks companies to do, organizations to do. So I think it's very peculiar, but also it emphasizes how important it is to understand standards and to participate in standardization activities in both cases. In the EU AI Act, standards provide a presumption of conformity for providers with all the technical requirements of the AI system involved in these types of high-risk use cases. And the requirements are logging of, recording the logs of the system, having a data governance system, a risk management system, ensuring transparency towards the deployer so that he has all the information it needs to comply with its own obligations. Accuracy, robustness, and cybersecurity are also there. Again, these are all applicable to the system itself. So the system needs to be equipped with all these elements that allow the system to function as good as possible to avoid any type of algorithmic discrimination or unfair or inaccurate outcome. I think, and this, by the way, enables providers to self-assess their own systems without recurring to a third-party certification, so they can do their own conformity assessment by themselves. So I think, in a way, it's a type of industry-friendly measure by the EU AI Act. If you will allow me, I know it's not popular to say this about the EU here right now, but we did consider companies and their needs at the time. In the US, it's different, of course, because, again, both developers and deployers need to, can use standards to prove their compliance. Yes. Again, my message is we are not that far apart. The EU AI Act is not as sweeping as it is commonly understood, and it contains also a lot of innovation-friendly measures, but also the role of standards is key in both the EU and the US for different reasons. I will stop here for now.
Thank you. Thank you for that excellent review. Of course, Europe can act in one of three different ways. They can either pass their own laws, they can reference ISO or other international standards, or the European Parliament can request Senelec or ANSI to create a standard. And the standards community obviously was rather jarred a few years ago when they switched polarity on that and said that when that third alternative happens, that only companies headquartered in Europe would be allowed to participate in those standards activities. So the interface between standards work going on in an organization like ISO or going on in an organization like Senelec is now a pretty sensitive issue. Do you have any reflections on what you see happening where?
Yes, I will start by saying that I also participate in the Senelec activities in JTC 21. So I do see firsthand how it's working out. The Commission indeed mandated only Senelec to work on harmonized standards for the EU AI Act, the ones I mentioned. But this doesn't mean that non-EU companies will not be able to participate. What it's meant is that there is another organization, standardization body, that is officially recognized in the EU, which is ANSI, that also contains Chinese companies, for example, and the governance system of that particular standardization body is not member state based, but just membership based. So meaning that companies can vote themselves and influence themselves the processes. So in order to avoid undue influence especially from China, this was the main concern at the time. Only Senelec were mandated to work on the standards, and Senelec work more or less like ISO and IEC. So basically every member state, and even broader than the EU actually, it's 34 countries have a membership in Senelec. They each have a national mirror committee, such as the US has into ISO, IEC through ANSI. ANSI represents the US in ISO, IEC. In Senelec, you have representation from the UNE, the Spanish one, AFNOR, the French one. But in each and every one of these national bodies, for example, American companies are represented because they do have offices in Europe and they have experts and they send them there. Microsoft has many. There are many international consultancy groups that are there, Deloitte, Accenture, you have many of them there. So it's not exactly true that non-EU companies are excluded from the process. They are actually included, and they can also participate by sponsoring individual experts as affiliates to support the process. This is something that some Chinese companies are doing actually, but just to support without trying to influence directly the outcome. So I think a lot needs to be debunked around the standardization processes. And also, what is true is that the EU takes as a basis what happens at international level, because standards are there to reduce trade barriers and ensure interoperability. It's in the interest of everybody to lower these market barriers for every company so that their systems can be interoperable anywhere. That's the role of standards. The EU just basically complements ISO, IEC standards by adapting them to the EU-specific rules. As I said, the EU AI Act, the requirements I mentioned, logging, accuracy, etc., have to happen at the at the level of the system because it is product safety legislation. ISO 42001 is not a product-based standard, but it's an organizational standard. So you cannot exactly implement that into the EU. That's just a translation that is happening in a way. So I wanted to specify this.
Thanks very much for that. Fabio.
Good morning. Great pleasure to be here. I'm going to take a slightly different take on the topic. I come from a more of a technical background. I've been working with the ANSI national accreditation body, which is ANAB, to think about like the use of AI in the accreditation space. But my focus on, or really my impetus to try to start to work with ANAB is really came from my professional trajectory. And let me tell you a bit about it because I think it's going to be relevant to how to tease out where we are and what needs to be done here. So I've been working with, I'm a physician by training, but my life has always been with data science and work with technology to use automation. I started working with AI before it was called AI, using early forms of automation that basically to improve workflows, improve activities in high-risk industries. This is something that took many flavors, but a lot of it was this type of predictive models that would use existing data, non-data from any source. Could be a retailer, could be a medical practice, could be a HR of a company, and that all that data would be used to predict something that will happen, meaning if that new employee will be good or not, or if that customer would buy or not, and some things of that nature. This was pretty much the AI up to a couple of years ago. And this is what we call narrow AI, predictive AI, traditional AI. This is something that was very important, had high risk, had high impact, and up to 2022, that drove 10 years of work by the legislations and by even the beginnings of the EU AI Act, and a lot of the standards have been developed. Even the 42001 was developed in the context of this type of AI. That's relevant. That's very relevant because now we are thinking in a state of confusion. We have a lot of things that were built initially, for the most part, around this type of AI. And then something happened in 2022. In the end of 2022, a new form of AI came about, which is what we call generative AI. And then that became more and more pervasive through 2023 and 2024. It also became clear how it operates and how it works and the impact in society. I mean, we are all here in this conference talking about AI, caring about AI because of the second type of AI, not because of the first, because it's really something that is taking a huge, making all of us think about life and education of our kids and our future. And that's really the key, right? And we're in my career has always been focused on bringing products or testing products of the first type of AI, and evaluating, using standards, getting to do test and validation for those things to be packaged as product, so that the FDA and regulators could do appraisals and the customers could buy it based on those specifications. When Gen AI came about and was in this space, 2023, 2024, and I realized, oh my God, none of this is going to work. This cannot be treated strictly as a product. There are some things that we have to consider this as a product, but for the most part, it's really something that would take a life of its own in the hands of the user. the user will have at least half of the play in terms of how the AI is going to work, how the risk is going to emanate from that use, how the risks are going to be mitigated. So what to do now? And then by the end of 2023, the new possibility came about, which was with the launch of the 42001, which is focused on AI management systems. And that's how I began to talk to ANSI and Reynaldo and the team here. Because it became clear that that standard itself, because it's centered on how the AI is sourced and used and really implemented in the organization, could really become the way where these things could be regulated, managed, and how we began to imagine an ecosystem where all the companies up and down the supply chains would be using these AI management systems and have these AI management systems be auditable and be really the source of truth when things happen, when litigation comes about, not because they will, it's not a matter of when, if, it's a matter of when. And that became really the impetus of really this focus on these standards as the way forward, because it was really tailor-made for this new form of AI. The Gen AI, because it had the characteristics that went beyond the product-centric approach. And that really even took another turn, like at the end of last year with the emergence of agentic AI. Agentic AI is really the compilation of processes that the organization can set up, where multiple steps can be taken, sometimes autonomously, by the Gen AI models to do things that are in the interest of the organization. So right there, you have something that's really like on the other side of the table in terms of from a product-centric approach. So right there, we need something that it's become really even clearer that the conformance assessment here, the standardization process, everything has to be kind of focused on how these agents are implemented, how they are monitored, how the privacy of the data, if it's dealing with private data, is protected, how the risks are mitigated, how errors are handled, and how that thing is going to evolve. And I think that's really what's going to be coming to be. The focus on the AI management system is going to be paramount. I think this is something that is becoming clear. I can say from the specifically in the healthcare setting. I also have a major contract with the government. So this is something, the management of the AI at the level of the organization and implementation, with the understanding that's not going to be a product. This is not a refrigerator. This is something that's much closer to a human being. It's not a human being, cannot take liability, but it has to be taken and managed and understood in a way that's closer to that side than to the refrigerator side. So with that, I think it's very provocative. I think we have to understand that we are in the state of confusion. Some of the regulations, even the ones that have invoked the 42001, like the Colorado one that was mentioned, they still are tainted because this thing take time to evolve. And when they talk about many of the provisions of this law, the Utah, the Colorado, it's all about anti-discrimination. And if you look at between the lines, what they're trying to achieve is really, they're really talking about the first type of AI, which is not really the most relevant here. So, and we are in this state of confusion. I think maybe my take-home message for you always to, when you look at AI, I mean, both things are AI, but they're really different, they're fundamentally different, they're built differently, their bias emanate differently, they are mitigated and treated differently. So it's not that the first type of AI is going to disappear, it's going to be some litigation and things that relates to it that are still going to apply, especially in manufacturing, things that are more that you need determinism. So it's not like they're going to disappear. But every time you look at regulations or a way to protect, you really have to make this distinction if you're talking about the first type of AI or the second type. So yeah, I want to stop here so that we have plenty of time to ask questions.
Thank you very much. You know, as lawyers, we're constantly looking at new things and having to decide whether they're really new things or whether they're just new wine in old bottles. When you look at Gen AI and agentic AI, what do you think is not wine? What do you think is new, or do we just really have to adapt old rules to the new realities?
Yeah, they're fundamentally different. So let me elaborate a bit on the point that I brought up. So when you talk about the first type of AI, it's really try to emulate something that was 100% constructed by humans before. So if there's something, like for example, if they're taking HR data and taking like something about characteristics of the applicant or being a number of years of experience and in one side of the equation. The other side of the equation is that how many of what's the correlation between years of experience and actually that the applicant makes it through the process, okay? And there's always something like this. So it's we will be teaching the AI always something that's really that came from a human experience. And sometimes that human experience is biased, right? Sometimes the rationale for in terms of applicant selection is built with bias because it came from the humans. So, and when you try to treat or mitigate the risk of this AI, you really have to care a lot about the data, where it came from. And so that's why it's not that these legislations are built they're not misguided, they're all very mature, but that's for that type of problem, because that really depends on the source of the data and the way it's constructed, et cetera. The second type of AI was built really from a different premise altogether, from the ground up, very differently. They found out that, I mean, they started with a different objective, but they started with the idea that they needed to do something, they were really aiming to do something that's more general intelligence. They wanted to have something that would have much closer to the human behavior. They would be able to interpret context, which is the first type of AI does not. You'll never do, just because the way it's constructed. This new form of AI had to be some understanding and contextual and link things, link events, link the case, the fact that we are here in the conference room is a legal topic and it really understand it. It needs to have some understanding of which way is up in the universe from every aspect that we care as humans. So the way they did was, okay, they built like some thing that worked, but then they loaded information indiscriminately. They're not labeled information, good and bad, to that thing, to that kind of filter. And that filter kind of captured through some statistical modeling and some fancy math, capture what's happening with the universe. What's the conference? What's the legal issues? What kind of topic could be and should be emanating in a panel like this, right? It built some understanding of how things work and how art is created, or how a book is created, and how you in your case think about law, right? So that's how they can create a book about that comes from you. And that's different, right? This AI is not a database in the strict sense. So that's why it was really illustrative to see the case from Claude and the Meta, because the fact that they had a database that was illegal that got them in trouble, but the fact that they're using that, they say it's fair use because, as a matter of fact, what the AI is doing is very similar to all of us are doing, right? You go to school, you go to higher education, and you read a bunch of books, talk to a bunch of professors and colleagues, and you learn, and then you use that. They're pretty much making the case that this AI, through this construct, just did the same, just ingested everything indiscriminately and learned, and now it's spitting out things. So they're fundamentally different, and the way you treat bias on this one, on the first one, is to really curate the data. On the second one is really to basically create all the layers to say, just like you do with your kid, with the humans, it's like, okay, this is a bad behavior, don't do that. Or when you have this question, go ask someone else before giving an answer. And that's really how you mitigate risk or you really control the behavior of that thing, which has a mind of its own.
Thank you very much. Brian, you get the chance to bring this all together from the industry perspective.
Great. Well, thank you, first off, for including me in this panel. It's an honor to be here, and can't tell you how much our whole community, small business developers, appreciates it. I think, probably preaching to the choir, probably by saying that, that AI development, as it accelerates, increasingly accelerates, I think all of our challenge is to find that balance in legal and regulatory frameworks that protects users and upholds trust, while fostering innovation. Just to give you an idea of where I'm coming from, my association, ACT, the App Association, it's a not-for-profit trade association that's based in Washington, here in the U.S., that represents the small technology developer community writ large who are working on many of these use cases. We have members who are operating in consumer and enterprise verticals and residing at all points in value chains within those verticals. Some are high up and doing more, I guess you could call it foundational development of AI. Others are modifying that and deploying it much further down, and others are just users of AI tools. So there's a really, that's a challenge you can probably imagine for a membership organization like ours, to find those threads of agreement across such a diverse community on any issue, but on this one in particular. But fortunately, I think we have found some. I mean, just thinking about some of the challenges which can be unique or even just sometimes more acute for small businesses. There's certainly compliance, complexity, and legal and regulatory fragmentation issues. Typical companies that are members of our association don't have in-house legal. Their CEO is their COO, is their CFO, and paying outside firms to represent, to do work for them can take away resources for a full-time employee or research and development. So it's a pretty serious issue for them. Differing rules already across important jurisdictions, the U.S., the EU, where it can overlap, can even conflict. We've found in practice. For example, just not to pick on the EU at all, but but there's new regulations for digital platforms themed in interoperability versus requirements for maintaining privacy and verifying age to prevent online harms to children, and those are difficult. They can be difficult to navigate sometimes, because especially for smaller companies that have fewer resources to keep up with changes in the law and budget for compliance. I think there's also issues with transparency in standards and in legal obligations, and I mean, I'm saying that because I do believe, as I'll probably talk about a little bit more, that standards, and this I'm sure everybody here agrees with, that's why you're probably here, but that standards have a critical role here in establishing norms and baselines, and that there should be an interplay with regulations where appropriate. What are the barriers to the development and use of the standards themselves is something that we often think about. There's the practical resource issues that face our members, but there's some aspects that there's a real lack of clarity. The copyright issue, there's that persistent incorporation by reference issue that affects us all. There's a lack of, another IP issue, a lack of clarity on when patented technologies are contributed into the process, if they're actually essential to the standard, and how one can even track that or meaningfully engage, and what the obligations are associated with voluntarily contributing those patents to a standard. I would just name maybe one other area of that's a challenge: cost and scaling and certification burdens. So in meeting standard specifications, the smaller companies we deal with inevitably struggle. to deal with and pay for certification, auditing, and compliance checks, and those are challenges, too. So as a community, going back to that finding thread of agreement across all these diverse members, we've really worked over the last up to even 5 years, maybe a little longer, to try and find some recommendations to policymakers, and I think all of you are policymakers, not just government policymakers, on a recommended approach to AI governance, and we've come up with this set of policy principles. I'm not going to read them all to you or anything like that, but I would love to share them with anyone. You can find me afterwards or anything like that. But they cover areas like quality assurance and oversight. Thoughtful design is a principle that our community is pretty committed to, the idea of thinking about risks and mitigating risk from the earliest stage of design. Access and affordability, transparency, bias and ethics. I know that came up, and there is no data set that will not have some bias, and it needs to be thought about. Even education throughout that value chain, including the end user, is important, and intellectual property rights issues. So we're continuing to represent our community across all these jurisdictions where AI policies are taking shape, and there's no shortage. We talked about bigger ones here, but I can probably think of just in Southeast Asia, I think in the last 6 months we've interacted through formal comment writing and other advocacy with 4 or 5 countries, and it's very, very difficult to manage, but it's also very important. One of the key tensions I think I was going to call out is at that intersection of standards development and conformity assessment and legal accountability, and again, I just want to emphasize for us all in the ANSI community that I think that standards bodies and conformity assessment organizations have a critical role in shaping AI governance frameworks, and they should. Enhance safety and security and interoperability, but market-led standards, coordinated with thoughtful regulatory guardrails, and I think that offers a promising path to balancing this innovation and trust, this trust and privacy protections, et cetera, with the giving companies room to innovate. I think I might stop there, Andy. I appreciate everyone's views so far. I hope I kind of have built on those a little bit and shared a little bit from the where the rubber is maybe meeting the road, and can take any question that you have.
Great. I'm wondering what you think about this scenario. If you think about IT security, everything changed when the internet came along. Because if you had perimeter security before you had security, and after that, unless you were air gapped, you had, infinite potential liability. So we sort of went through 4 phases. In the first phase, everyone just ignored it until hackers got to be good enough that they couldn't ignore it anymore. Then security was treated as an aftermarket product. And then finally, users, started to be unhappy enough that vendors had to take security seriously, but still weren't necessarily making it a design imperative from the beginning. And now finally in the EU, with the Software Security Act, government is saying, no, you have to design in security from the beginning or we'll hold you liable. Given that that's where we are, now that AI comes along, how do you see that playing out across that, where we are at this point in time after that evolution?
There's a lot to take from that. I think that's really insightful, I think, to call out that evolution. And maybe we're living through that now, but maybe we can short circuit it. Maybe we should, But the theme you're raising, the liability question, is so critical and is even for some of these smaller companies who are trying to be as nimble as possible, are forced to think about these issues when they're approaching a group for funding, for example. When they're trying to forge some new partnership, they're getting asked questions about liabilities related to AI. So, there is this looming question, and it's a really fascinating one, about what is the appropriate distribution of liability across a typical health AI value chain. Just previewed. I was going to bring up health because it's a great example. But there's a lot of uncertainties. You've already heard a lot about uncertainties, and for example, George was covering copyright earlier. There was talks about different states. I mean, there's a real debate right now around whether AI should even say you go into a state court with a tort case. Is it a product or a service, and what is the burden that you would face as a defendant, when AI is in play? And states, like, as has been mentioned a few times here today, states have begun enacting a diversity of AI-related statutes and regulations with different scopes. Most of them are seeking to address the kind of famous use cases, and deep fakes, generative AI voice cloning technology, Tennessee, and things like that. California just passed an interesting law about general transparency and disclosures for foundational developers. But the state courts, under the existing laws, have been, in my opinion, inconsistent, and that leads to uncertainty. At the federal level, there's, and this is me blurting out health earlier, previewing my own example, but there was a really interesting exercise that we went through as an advocacy organization about 2 years ago or 3 years ago, where there was a federal agency, the Health and Human Services Office of Civil Rights, which makes regulations under the Affordable Care Act to prevent not discriminatory outcomes in a healthcare setting. And recognizing that they could only touch the deployer, the actual doctor using the AI with the patient at the end of that whole value chain, they adopted a regulation that put effectively strict liability on that user, recognizing that their authority didn't allow them to touch anyone else in the value chain, and their thinking was, well, if I put strict liability on this actor, the chain will just figure it out, But I think what they weren't appreciating, what we really advocated on, was that it's a great reason for an in-house counsel to say, no, don't pick up and use that tool. And that's a bad public policy outcome. So what they ended up doing, I think, was stepping back from that and just putting a reasonableness standard on it, which was great because we've been thinking a lot about this question too and trying to be as proactive as possible. And we've developed this framework. Again, it's something that I wanted to be sure to mention here that I can share with anyone about what we think some reasonable recommendations are for the distribution of liability in an AI value chain. They mostly come down to knowledge and intended and reasonably and expected uses, and the ability to do something about the risk that's been identified, rather than putting over assigning risk to any certain point in the value chain. And because we do believe that the standards play here is so important, we mapped that to the NIST AI risk management framework functions. And so I hope it's a good contribution to the public debate, but it's very unsettled right now.
When you look at what a dismal record we have on personal data, we tackled it well with healthcare, with HIPAA, decades ago. But when it came to things like credit card data, 20 years on, we still don't have any national legislation. So what industry is stuck is 50 different states with all their different flavors. Would industry be better off with a national law? And if so, what should that law say?
Absolutely, yeah, I do believe so. For me, there's no question that one rule rather than a patchwork of all the states and territories in the U.S. alone, and never mind other places having different requirements is, and companies live that now with cybersecurity outage or breach reporting, for example. So it's tough to comment on the likelihood of Congress doing much of anything right now in the middle of a shutdown, sadly. We're still in a shutdown unless some news has broken here while I've been up on the stage. But guessing no. Um, but I think ultimately, if we could get a risk-based standard adopted in a cross-sectoral data stewardship or privacy law for the United States, that would preempt states and would do as much as it can to avoid creating an adversarial dynamic. What I mean by that is, if we're too focused on enforcement and finding companies, and there's not enough focus on working with them to advance their practices, then no one wants to talk to one another, and that's not consistent with public-private partnership, in my view. So there's what has stopped national privacy legislation from advancing? I mean, I think that dynamic is sort of in play in some of the key sticking points. Like, for example, there's a debate about whether a private right of action should be included. The idea of unleashing the plaintiff's bar, not to besmirch our profession here, on companies, especially smaller ones, under a new data privacy national standard somehow is pretty scary and something that we fought against. So those are the kind of things that have stopped it from moving forward. But I'll put on my optimistic and rose-tinted glasses and say we're going to have Congress. We're going to have a funded government soon, and and maybe we can further progress the debate on national privacy standard through Congress.
Great. Well, thank you very much. I've been encouraged to see how many people have been looking at the stage instead of their laptops during this great panel discussion. So I'm pleased that the panelists have been connecting. So now it's your turn. We have, I think, about more than half an hour to take your questions, and we would be delighted to take them. When you do, please use the button on your microphone. Please identify who you are, and you can address your question to anyone or to any individual on the panel. I know you're not really shy, but no one wants to ask the first question. Yes, sir.
Vijay Krishna with the ANSI National Accreditation Board. So right now, I was in Geneva last week where the ISO 17024 standard was being revised. That is the standard for certification of persons, certifying body certification body that certifies individuals. And that would be the first among the CASCO standards that has a set of requirements for a certification body. Mm-hmm. So my question essentially is, historically, we have looked at process outcomes for a lot of ISO standards like 9001, 42001. Mm-hmm. And then you also have looking in terms of output assurance. So should we be looking at process assurance or more looking at output assurance, more in terms of validation, algorithmic transparency when you are assessing a certification body? So my question to the panelists is, based on your experience putting together all the multiple hats from a legal defensibility to experts in terms of validation, reliability, what would be your preferred way of assessing certification bodies to have confidence that there is human oversight, there is transparency, there is reliability in terms of the AI models?
Thank you. Who wants to field that one?
Yeah, I will start. I think it goes back to some of the comments that were made. It does matter what type of AI you're using, but in terms of if you're applying the agentic AI or Gen AI, agentic AI in that organization or to the we will need to think about how that is being applied, how that's being sourced, what are the risks involved in terms of leaking of data, use of data for that specific use case. All those things that relates to that would apply to the standard have to be analyzed. A lot of it will be at the organizational level, but some of it will be at the technical implementation level. As it applies to the personnel standards or conformity assessment, we are going to have, again, differences in terms of how the AI is used in the organization that as relates to evaluating human capabilities and in terms of the conformity assessment bodies, we need to really think from the top down if they're prepared to evaluate these things in the context of not only traditional AI but Gen AI.
Yes, if I may add, I think one of the biggest challenges in standardizing AI in general, whether it's at process or governance or product level, is how fast AI is moving. So how are we moving from narrow AI to big LLMs to now agentic AI, et cetera, being quick in updating the competencies so that we are sure that the certifiers are up to speed on every single development is a key element, and also being able to quickly update the standard itself is a challenge in AI standardization in general that needs to be tackled.
Yeah, it's a great question, and I'm just thinking like kind of the practical like things that have been tested that have kind of worked for, certifying to standards. There's been a couple again with the health use case. There's been a couple attempts at this. One was called Exertia, XCERTIA, later called Haptique, and now it's in the form of an organization called the Coalition for Health AI, or CHAI, where they're trying to come up with, outside of government, a set of criteria and then a set of assurance labs, and it remains to be seen whether that will take off. It's like how do we get the assurance how do we all get the assurance we need of quality and safety from these processes without having it be too onerous or too expensive? So in the past, they've tried self-assessments and attestations and then essentially market surveillance, and I don't know if it has worked. I don't have an answer. I'm just saying that if you're interested in a use case and maybe there's lessons to be learned, you could look at kind of the healthcare and AI space. Maybe AI tools themselves can help us reduce that cost in automating conformance testing. Just an idea.
Kind of hard if you're still trading records on telexes and fax machines.
Or compact discs.
Maybe they'll catch up.
Yep.
Other questions? Patty.
I don't know if this is on. Is this on? Okay. I keep pushing the buttons. So there are a number of SDOs in the audience, and they have original works of authorship in their standards. And we've heard a lot of commentary on how the law isn't clear. The Anthropic case is going one way, the Meta case is going another way. Congress isn't stepping in. So what's an SDO to do to protect its content from the claws of LLMs? Does the panel have guidance to offer to the SDOs on how they might protect their copyrighted works?
Well, I might lead out on that one. I mean, one of the things that standards organizations always forget about is that their trademark is worth as much or more as their copyright. If you have standard X and you own, whether you've registered or not, the name standard X, no one else can claim to have that standard. The fact that people might be using LLMs for training doesn't violate the copyright that you have in that, and arguably, an LLM might be able to do something faster than a committee of people sitting around in a circle. But I'm not quite sure. it doesn't strike me as being a big issue compared to the world we have today, where another standards organization could look at your standard and learn from it, but they can't knock it off. Am I missing something?
Some of these standards have been incorporated into and used to train LLMs. And so it will, depending upon how the LLM acquires the rights to do that, be some of the good properties. How will they be able to protect against the claim of fair use?
I see, okay. I mean, I think a standard is no different than anything else from a copyright perspective. So standards organizations can just follow, where the courts go. It doesn't seem to me that it would make much sense for them to fund their own, challenge. I mean, there's so many other people with more skin in the game, or at least bigger budgets. But I should ask the rest of the panel whether someone thinks differently.
Yeah, in terms of there are multiple types of standards, but if you think about some of them that have that provide a structure, basically a roadmap for auditors, for example, the 42001, I think the value of the standard that I don't see, even if the LLM ingests it and have an intrinsic understanding of the standard, I don't think there's any detriment to the value of the standard in any way. I think it just becomes easier for any organization, in a sense, to implement it, to understand it, to contextualize to their own needs. The 42001 is one standard that is applied across all industries. And I think the use of GenAI, I think, makes it a more democratic, the usability of these type of approaches, it becomes more democratic. And then you have other types of standards that are more normative in terms of the solution have to do A, B, and C. And again, that's not something that necessarily is under threat by the use of AI in this context. So I might be missing something, but I don't see any issue for SDOs with this technology.
I think from an economic point of view, if people are just, using the top 10 LLMs, where you're talking about, losing the income on 10 copies of your standard. On the other hand, if agentic AIs start having, hundreds of users, then using a standard as a training data that wasn't already a part of the training data, then I guess you could get into some real revenue loss. But I'm not quite sure whether we could take it farther than that at the moment. The good news, though, like I say, is I think you can just ride the coattails of where the rest of the industry goes. And unless you could differentiate yourself in some way from the rest of the industry, you don't really have much choice anyway. Other questions or differing opinions? Sir.
Yeah, quick question. And obviously in the development side, given how much AI is being used to draft and summarize content, especially in the digital space right now, that we're engaging all of these digital tools, how far can someone involved in the standard side development go into using AI tools before running into issues from an IP perspective, ownership, confidentiality, consensus, integrity? Where is that line? Have we found that line yet? I know it's very early and precedence has not been established as much as we would like. Where is that line? Because we're in the process of developing standards utilizing these tools. Christian Thiele, SAE International. So if you have some help there, that would be great.
Volunteers from the table. I'm sorry. Oh, good. Yes, please.
Well, my mic isn't working, but I can sort of address that. I touched briefly on it, so I think I'll just try to project. So I think your question is about the output side. Oh, right. Oh, you did it. Thank you. Amazing. So I think your question is touching on the output question for the user. Could the user be infringing? Right now, under the Copyright Act, the line is substantial similarity. So if the output is substantially similar to a copyrighted work, there could be liability for the person generating that. And that makes it tricky if you're dealing with AI that's trained on copyrighted works, where there's risk that the AI is generating something that's copyrighted. You might not know that as a user, and copyright is strict liability, so you don't need intent to be infringing. So that's the tricky part. Now, some AI companies specifically tout that they do not train on copyrighted content, that they take steps to avoid that, and that's part of their marketing strategy, so that's one thing. Other companies are taking steps to put up guardrails to prevent their AI tools from popping out copyrighted content. So there's steps that people are taking in the market to avoid that, recognizing that users want to avoid infringement. But the answer right now from a copyright perspective would be, yes, there's a risk, especially if you're using a tool that's trained on copyrighted content.
The good news on that one is that unless it settles, the New York Times case, addressed that directly. Now, the defendant said, they went to excruciating lengths to create prompts that had no choice but to mimic an article that had previously appeared in the Times. But as I say, if it doesn't settle, at least we'll hear a court, address that issue. Whether they'll address it helpfully or whether they'll deck it, we'll just have to wait and see.
Yeah, and I think what we're doing right now too is we obviously have a compliance and an AI policy within our standards development organization, within the bodies and the committees that are working on it. So we're being very cautious as it relates to what they can use, what tools they can use, if any, right now from an AI perspective, because otherwise we would, as you said, there is risk out there. You don't know what you're getting at times, and you have to be very careful until those tools are better developed to truly focus on avoiding the IP confusion. Thank you. Appreciate it.
Thank you.
I was going to say do so legally, but those were much better answers that I think you just heard.
Yeah, and the other aspect to remember is that for the most part, you cannot get a AI like this. You should not be able to get an AI to spit out a standard. Even if it tries, it's going to be as good as anybody that works a lot with the standard to recite or think about the main areas, but it's not a database. It's not technically speaking, should not have like a full detailed representation of the articles or New York Times articles or the standards or anything that ingests. It uses that information to create like a statistical models to understand what is there, but it cannot really replicate. So that's really a way to think about it.
It's on? Okay, good. Well, as long as we're asking difficult questions.
That's the
You
idea.
open the door. Thank you.
Right.
From a standpoint of a requirement that you provide a standard of care in the work that you do, one of the associations I'm familiar with has just rolled out their own version of AI that is designed to help the engineers do their analysis based on the codes that they develop. Now, if that tool gives you a number that is not the right one and there's an accident, an incident of some kind, where does that standard of care come in and how is that liability going to lay out? I know that's early on in the process, but it's just a question I have as more and more associations and SDOs look to roll out their own product to help their members use their codes, sort of where does that line get drawn?
Well, first, as an observation, not to duck the question, but just to observe, commercial agreements are going to work this out in indemnification provisions. So, while we're waiting for the courts, companies are going to battle this out. Who owns the liability if there is a liability? So there will be real-time answers that I imagine will probably gel relatively quickly, and then we'll just see whether the courts upset those conventions or whether they follow those conventions. Other thoughts?
Yeah.
Go ahead.
I think it's a great question. I think it's a main reason why we are here. It is the ability to show that you cared, that you were prepared, and you did everything to avoid that negative thing to happen. Is something that you cannot really. you cannot really point to prospective. You have to point to something that you did in the past, right? So the way to protect yourself in that instance is to say, well, 3 months ago, we set up a system, we thought about this possibility, we created this way to mitigate with the possibility that it would not work, and if it didn't work, somebody would be called, you do this, you shut down the system. We thought about all these things, and you put that on paper, we put that in a documentation of what we call an AI management system according to the ISO 42001. So I cannot think of a better way to really to protect yourself in this case and to show that you have standard of care, especially if this is a AI management system that's has been audited and certified by a third party. So it's really along those lines you can show that you had that you had been prepared well by just doing the type of due diligence in advance.
Yeah, it is a great question, by the way. It's a really great question. And the only thing I maybe would add on to what you've heard is you know, I guess I'm thinking about the hypothetical that you just put out there and trying to apply, you know, some of the principles that we developed with our members about the distribution, the appropriate distribution of liabilities in a value chain. And, you know, I think it sounds to me like you're describing an intended or expected use, and you know, and in the deployment of it, you know, if those numbers were like deployed blindly without doing any checking, no human in the loop, especially when safety of life is an issue, which in our hypothetical it is, yeah, there might be some liability further down in the value chain rather than just kicking it all up. But the practical reality that Andy pointed out is also really important, I think.
I think, if I may add, it also depends on the type of incident. Like there are several types of incidents. Like disruption of critical infrastructure is a big incident. Death, attempts to death, a risk of death to a person, unfair outcome in a mortgage decision. It really depends on the gravity of the incident, but indeed, whenever you can, as has been said, whenever you can demonstrate that you were implementing a standard such as 4201, for example, you already have a means to show that the reasonable care was applied. There are incidents that are not even, I think, regulated at all. Like, at least in Europe, you would be surprised, but many incidents related to AI systems that do not have to comply with the EU AI Act, which are many, would not even be taken into consideration by the EU AI Act. And that's just what I'm to complete the picture.
Thank you.
Hi, I'm David Cranberg, Intellectual Property and Distribution Specialist at the American Petroleum Institute. Sorry, I'm kind of facing away from y'all because this is the way the microphone is, but thank you all for this great discussion. I believe that Brian hinted towards some California regulation which included like accessibility in terms of like AI companies, which kind of led me to the broader question: what is the capacity of government, regulatory bodies, or the courts to direct how these AI systems operate?
I'm sorry, the capacity of them to do what?
To direct how the AI systems like operate within, you know, if whether or not they're able to like generate original works or like reference original works, things like that.
One sort of observation, if I heard your question correctly, is where is that going to rank in the things that people are worried about? So that would be, that one doesn't strike me as being towards the top on people's radar screens, but that doesn't mean that it isn't, you know, important. Other thoughts?
Yeah, that is a little. Yeah, that doesn't seem like the prospect of a judge directing the direction of a technology being developed is a little scary to me, I guess, you know, at least unilaterally. But, you know, something that crosses my mind, and you can take, you know, draw your own conclusion from whether this is an effective construct or not. But I'm thinking about, you know, there's to make a long story short, an antitrust case related to a company called Epic Games and Google, as far as the operation of their App Store digital platform. And in the crafting of the remedies, this judge has behavioral requirements on Google at this point. And they created like a sort of a 3-person commission. So somebody representing each party, and then kind of a third person who's supposed to, you know, be on neither side of the V and have the public's best interest in mind. And and they have an immense power in evaluating whether the behavioral remedies are being followed and whether the judge should step back in and things like that. That's a construct. I think I can tell you that for our community who is deeply impacted by such a case, there's essentially no representation on that commission for the small business developer community. So you can imagine we have a problem with it, but there's an example, maybe, of that. Now, should it happen or not, which I think was the question, is maybe something I'll let you all come up with your own answer for. You probably have a sense of what mine is.
Right. Yes.
Hi, thank you for this. Been really interesting. I have a relatively naive question. I'm not a legal expert at all, and I think it's been touched on already, but you know, because I'm not a legal expert, I can't tell. But I was wondering to what extent, you know, a strengthening of privacy rights, strengthening of privacy standards would address some of the other serious legal issues that you've been addressing today. So in terms of like standards for data minimization, you know, things like you know, restricting data sharing or maybe, you know, data brokering. All of this stuff makes it possible to do a lot of these things with these models. So how much of that would affect some of the legal issues you're discussing?
Well, I think a lot. I think is what I would think, and you know, I would. It's hard to future-proof any sort of language in a standard or a law, and that's why I get updated all the time, I guess. But whether AI is used or not, I would hope could not matter or not matter that much with the right data governance standard. So I think it would be important in that way. Hopefully, I don't know if anyone else has any other perspectives. I think it's needed.
Yes, no, great question. Privacy has at least 2 domains that you have to think about here. One is the personal domain. All of us and our kids, our moms, everybody's using this, and Google already knew a lot about us, Apple and Facebook, but everything's taken to the next level now with these apps. People talk about the mental health issues. People talk about the financial issues. They're ingesting all this information, making sense of it, contextualizing. They know you, and they know how you're connected to identity B, which is your kid. So that's happening because it's so useful. It's really helping you with whatever issue. So, and there's not really clear what's going to happen, because a lot of people will probably sign up for it, maybe sign off on the risk just because of the benefits. So we have this really interesting dilemma by society now, because there's so much benefit, but you're pretty much giving off your farm to this AI. But society are going to protect against harm is something that I think it's just not been defined. The second one is the privacy around the intellectual property of corporations and companies and the commercial interests. Again, any company would have a lot of people using this AI in their own capacity, loading client data, loading customer data, loading strategic information to this AI to get inputs. And in many organizations, most of them, big and small, this been done indiscriminately, without care, without the duty of care, as of 2025. And that's, nobody knows the size of this problem. And in that case, there's not really a regulation, just the absence sometimes of a local practice or really of a local effective system to make sure people can benefit from AI without giving off the farm. So this is a huge unsolved issue.
Yes, if I may add, privacy and AI governance are very strictly correlated. In fact, I talked to several privacy experts here in the US who maintain that without a privacy framework in the US, there will never be an AI one, because the privacy one is the foundation. Without that, any governance system you implement will be missing an element. And that can be tackled through standards to a certain extent, but not necessarily that comprehensively. And the fact that in the US the privacy bill failed at federal level doesn't bode well for the AI work on AI, because privacy, the way we treat privacy now is also because of automated decision making. So the challenges in privacy, in personal data protection, are there because of the use of these automated decision making tools that then became AI systems. And so the legal problem with privacy emerged particularly with that, and so they are very intrinsically related.
Great. Well, we have less than 5 minutes, so why don't we close out with one of those famous lightning rounds. Here's my question for you. What do you think is the toughest legal question or legal/societal question that AI poses, and are you optimistic that it will be well resolved, or if it will be resolved? So start with you, Fabio.
I think the assignment of liability is unclear. I think it, like I alluded to, I think it has to be ideally managed locally, but there's so much opaqueness in the system, and some of the things would emerge because of multiple layers of things that can be faulty, not only the large language model, but the data that goes into it in terms of the input that we used. There's so many things that can go wrong, and the assignment of liability I don't see how that can be structured in a simple way.
Well, I'd agree. The solution, for better or worse, is probably going to be there's going to be some piece in state courts and state law, and then more at federal level, and hopefully they all can align as best they can. But the liability question is a big one. I mean, I guess I would just say, I should have mentioned this earlier too. I'm going to keep running with the healthcare theme, so I'll keep doing that. But part of the inspiration for our organization to really pull our members together and come up with that framework I was talking about was just observing some existing, use cases and dynamics. For example, in the healthcare space, when there's like a cyber breach at a hospital, and at least only for public perception purposes, you'll see the hospital pointing their finger at the medical device manufacturer, the vector for the the attack, saying it's 100% their fault, and the medical device manufacturer pointing back at the hospital saying they didn't have a risk management, and it's not our fault at all, 0%, and they're fighting and finger pointing. And if we have that dynamic going on with AI, I think that'll be really, really unfortunate. Hopefully we society can all come together and agree on a shared, the concept of a shared responsibility for liability.
Yes, I would agree, and if I may add a level of complexity to this legal question, it all relates to the concentration of power that AI introduces and the risk of power asymmetries. Think about, again, the different actors in the value chain trying to pin the responsibility on each other. Whoever owns the system in the end will be the most protected and the most powerful, because it's just too hard to prove otherwise. And at the end of the chain is the consumer, who sometimes will have the burden of proof, at least in Europe. And good luck finding enough evidence to pinpoint the fault to the original developers. So in the end, this concentration of power is what scares me the most in AI.
Thank you.
Certainly not disagreeing or won't disagree with anything that was said. I think the only thing I would add from the kind of creation side is just the issue that we touched on earlier about, what it means to be an author or an inventor. I didn't really talk about the patent side, but that's the area I practice in the most. And so, the courts have reinforced that, like with authorship, you have to be a human to be an inventor on a patent, but certainly as human inventors continue to use AI to help create or conceive of inventions, I think there probably will at some point have to be significant changes in the law and potentially create a separate category of inventorship for AI-assisted or even AI-conceived inventions as the technology becomes more sophisticated. So the last time the Patent Act was significantly amended was 14 years ago, so it certainly is possible, and I guess I'd say I'm optimistic that would happen if it needs to.
Yeah, I agree with that. I mean, the potential of AI to advance inventorship is just so enormous that it can't be denied that it's going to happen, and I can't believe that the courts won't allow the rewards of that inventorship to incentivize further innovation. So to me, that one seems inevitable, and probably, I guess, likely would have to be done by Congress, but maybe the courts would figure out a way to do it. The one that I was going to focus on is just the incredible destructive power of AI for jobs creation, creativity. I mean, it goes way beyond the traditional creative destruction, cycle. If you look at, for example, as soon as ChatGPT came out, I wrote a blog entry that said, once these things take hold, why will anyone else ever write a blog entry? Because no one is clicking through like they did with Google before Google had summaries. Google was a stepping stone to content, and now that we have this intermediary level of content consolidators, where's the incentive, for anyone to create? On the art sides, on the coding side, it goes on and on. My personal view of something rather utopian, I'm sure it won't happen, would be that when a company comes up with an AI replacement for an employee, they can't just pocket the whole profit. Half the profit or more goes into a central, basically, welfare fund that, is going to provide, maybe it's the standard minimum wage for the amount of displacement that generates from this. Because it seems to me impossible that this isn't, when you take a longer view, 10 or 15 years, going to be colossally destructive of jobs. And then I guess the last thing you could focus on is some sorts of things are kind of going to disappear. The role of a creative in the arts is going to be very different from when it was a manual dexterity, driven. So with that, we'll close, but thank you so much for your good questions, and we'll all see what the future brings.